In an unfolding legal drama with national implications, the case of Kilmara Brego Garcia, a migrant allegedly deported in error to El Salvador, has become a focal point of controversy. The controversy centers on seemingly contradictory statements made by former President Donald Trump regarding his administration's handling of Garcia's return. What initially appeared as a promise to abide by a Supreme Court mandate has been called into question by subsequent public statements, exposing potential cracks in the administration's legal strategy. To understand the issue fully, it is essential to revisit the court's directive concerning Garcia. The Supreme Court's ruling clearly mandated that the Trump administration facilitate Garcia's return to the United States. In response, Donald Trump had publicly declared his intention to comply with the court's order, emphasizing his respect for the highest judicial authority. This commitment was unambiguously echoed in a recent statement where Trump asserted that he would ensure Garcia's return if the Supreme Court so directed. However, the narrative took an unexpected turn when Trump later disseminated a social media post that appeared to undercut his initial promise. The post, replete with its own measured rhetoric, announced that President B had, in effect, assumed full custody of certain violent alien enemies, explicitly including Garcia. In this message, Trump implied that Garcia was now entirely under the control of El Salvador, effectively suggesting that any responsibility for his return was no longer a matter for the U.S. government. The juxtaposition of these two public pronouncements has sparked vigorous debate over whether Trump's later comments constitute an outright repudiation of the court's ruling. This conflict raises significant legal and constitutional questions. On one hand, the original commitment was a straightforward acknowledgement of the Supreme Court's authority, a promise to act in accordance with the judicial mandate for Garcia's repatriation. On the other hand, the subsequent social media messaging introduces a contradictory element by shifting the perceived locus of control over Garcia to El Salvador, a stance that implicitly undermines the court's order. The legal community is now closely scrutinizing how the Department of Justice, DOJ, will reconcile these inconsistent statements in future court proceedings. The crux of the matter lies in the tension between public posturing and the binding nature of judicial orders. In prior hearings related to the Garcia case, it was noted that Trump's public commitment to abide by the court's ruling was formally recorded by Garcia's legal representation. Lawyers representing Garcia even highlighted Trump's initial remarks, which affirmed that he would bring Garcia back to the United States, if so ordered. Yet, within a short period, the public narrative shifted, leaving legal observers questioning whether the Trump administration might be prepared to flout a direct order from the nation's highest court. This inconsistency presents an unprecedented challenge for the DOJ attorneys tasked with upholding the rule of law. As the case approaches the next scheduled hearing, these lawyers find themselves in a precarious position. They must defend a legal strategy that appears to conflict with the president's recent public declarations. While there remains an option to interpret the social media comments as a mere lapse in communication and a flip-flop, as some analysts have described, the possibility that these statements signal a broader intent to disregard the Supreme Court's directive cannot be dismissed lightly. More troubling still is the potential for this situation to escalate into what many legal experts have termed a constitutional crisis. When the executive branch openly defies a judicial mandate, the fundamental balance of powers is jeopardized. The separation of powers, a cornerstone of American democracy, demands that each branch of government respect the authority of the others. In this case, if the Trump administration were to ignore the court order by citing its reliance on the social media message, it would signal a willingness to bypass established legal protocols in favor of political expediency. Such a move could irreparably damage the integrity of the constitutional framework and potentially invite severe judicial censure. The position of the DOJ lawyers is now subject to intense debate. They face the daunting prospect of having to justify a policy that not only contradicts a Supreme Court ruling, but also places personal accountability on their shoulders. History bears witness to the punitive measures that have been taken against those who have contravened judicial orders. Do you have controversy? In previous instances, outspoken officials who adhered too closely to legal truths found themselves sidelined or even dismissed from their positions. This history compounds the current dilemma, as DOJ attorneys must balance their professional duty to uphold the law against the risk of political repercussions. Indeed, the legal community is cautiously awaiting the next steps. The tension is palpable, with every flip-flop in the administration's stance serving to erode its credibility in the eyes of the public and the court alike. It has been suggested that if the Trump administration continues on this path, publicly posturing while refusing to act upon the Supreme Court's order, it may compel Judge Shinez or another adjudicator to consider sanctions, or, in extreme cases, a contempt of court ruling against the DOJ lawyers. Such an outcome would not only undermine the integrity of the legal process, but also set a dangerous precedent for future administrations. At the heart of the current controversy is a broader constitutional debate. The fundamental question remains, can the executive branch, and by extension its appointed legal representatives, ignore a binding judicial directive in favor of a politically motivated narrative? Former President Trump's recent remarks appear to suggest that he believes the answer is yes, that his personal prerogative as chief executive allows him the latitude to override such orders, especially if they conflict with his broader political ambitions. This perspective, however, flies in the face of established legal norms and raises serious doubts about the viability of the constitutional order if such practices are allowed to continue unchecked. Proponents of strict adherence to judicial mandates caution that even seemingly minor deviations from the rule of law can have far-reaching consequences. The Garcia case, as it stands, is not merely an isolated instance of administrative mismanagement. It is emblematic of a broader trend wherein the executive branch appears increasingly willing to treat judicial rulings as optional guidelines, rather than binding edicts. Such a stance threatens to undermine public trust in the justice system and calls into question the very foundation of American constitutional governance. To be sure, the implications of this case extend far beyond the immediate legal proceedings. They touch on a fundamental debate about the nature of executive power in modern governance and the limits of presidential authority in a system predicated on checks and balances. Should the administration continue to disregard the judicial order by leaning on politically charged rhetoric instead of adhering to the legal mandate, it would not only be defying a direct court command, but also challenging the authority of the Supreme Court at a time when its decisions are meant to serve as the final word in matters of constitutional interpretation. In conclusion, the unfolding events in the Garcia case represent a critical juncture in American constitutional politics. On one hand, there is the unequivocal mandate from the Supreme Court directing the administration to facilitate the return of Kilmar Abrego Garcia. On the other, a contradictory public message has emerged, one that appears to undermine that very mandate by suggesting that Garcia's fate now rests solely in the hands of a foreign government. This dichotomy poses a serious question for the DOJ attorneys tasked with upholding the rule of law, and it raises the spectre of a constitutional crisis if the Trump administration persists in its contradictory stance. The coming days are set to be critical as the case advances toward further judicial review. Legal experts and constitutional scholars alike are watching closely, aware that the resolution of this conflict could have lasting consequences for the balance of power within the U.S. government. As the story develops, it remains imperative for all branches of government to operate within the established framework of the rule of law, a principle that forms the bedrock of American democracy. Whether the administration will ultimately adjust its course remains to be seen, but the stakes could not be higher as the nation grapples with the potential unraveling of long-held constitutional safeguards. This report has aimed to provide an authoritative and comprehensive examination of the events surrounding Kilmar Abrego Garcia's case. The detailed analysis reveals not only the inherent contradictions in the administration's public statements, but also underscores the broader constitutional questions at stake, a matter that will undoubtedly continue to provoke robust debate in the days ahead.